XL Specialty Insurance Company versus Aircraft Holdings, LLC. Mr. Finley, are you going to argue for the appellant?
Yes, sir.
Whenever you're ready.
May it please the Court, my name is Tom Finley. I represent XL Specialty Insurance Company along with Rob Telfer, my co-counsel. We'd like to reserve 5 minutes for rebuttal. I'd like to start out by addressing the appraisal issue. The first action that the defendant took in this case was to move to compel appraisal. As the Court knows, the appraisal provisions are much like arbitration provisions. They've been treated as such by the Florida courts consistently. The events in this case start with a plane, a Learjet 35A, that landed in the Cancun airport with its gear up. All the experts have described it as a very gentle landing, but there was some damage done to the aircraft. XL Specialty was the insurer of that aircraft. It was one of many owned by the plaintiff. Immediately after the aircraft landed with the gear up, there were no personal injuries involved. XL Specialty sent a team from Westar Aviation from Grand Junction, Colorado, down to Cancun to evaluate to the best extent that it could the damage to the aircraft. The team from Westar Aviation looked at the aircraft, determined what they could from the situation on the ground there, and came up with began the appraisal process, essentially, to determine what the extent of the damage was. Immediately thereafter, XL Specialty forwarded the initial appraisal to the plaintiff. The plaintiff, not being satisfied with it, hired its own appraiser from Bombardier Aviation, and they sent their man down, Mr. Johnson from Bombardier, to do the same thing. Both parties were restricted in what they could look at. The employees in Cancun that were responsible for the runway down there told both parties, well, you can't open up the engines, you can't move the aircraft, you can't turn it over, which was essential for wing damage estimation, according to both experts. There were certain limitations that were just impossible to fulfill. In March 10, 2004, the plaintiff finalized its appraisal of the damage to the aircraft, and for the first time put some estimation of engine damage in their appraisal figure from Bombardier. That was forwarded to XL Specialty with a cover letter that said, we demand that we proceed with Condition 10 of the insurance policy, which is the provision that provides for mutual appraisals. Now, at this point, we were already both involved in the process, but neither party had issued a written demand at that point. But the plaintiff was the party that initiated at least the written demand for the appraisal that was already taken place. And it's clear that it's not a matter of both parties agreeing, either party. And that's one problem I have with the trial court order, is that it says the defendant waived its right to demand appraisal. Well, in this case, the plaintiff demanded appraisal. When its appraisal was complete in March of 2004, it demanded appraisal. There's nothing that we have to respond to in that event. If there's a disagreement over who the umpire should be, the appraisal process provides we have an expert, they have an expert, and then there's a neutral third-party umpire. If the parties can't agree on who that umpire is within 15 days of the demand, in this case within 15 days of March 10th, then the process provided for in the insurance contract is for the plaintiff or the other side to go to court and have the court order who the umpire will be. That's not what happened in this case. Instead, in this case, the plaintiff filed a lawsuit on April 14th of 2004, just approximately 34 days after they finalized their appraisal and demanded appraisal. Our first action, XL Specialty's first action in the case, was to file a motion to compel appraisal and to dismiss the case from the circuit court. The trial court denied that motion and held, quote, an appraisal is unnecessary to determine the amount of loss because the contract terms establish a value of the aircraft in the event of total loss of $2.4 million. Well, to us, that makes no sense at all, because just because the policy says that the insured value is $2.4 million doesn't preclude there being a dispute as to how much damage was involved in this particular landing. That was the issue in the case, and there was a wide disparity in the valuations at that point.
Is it conclusive in this record, counsel, that what Bombardier did on behalf of the aircraft owners was an appraisal, as that term is used in the insurance contract?
Is it conclusive? I think that that's the way the parties were proceeding. That's my understanding of the way the parties were proceeding. I don't think there's
Is that
any...
supported by the record?
I would say so.
That they were invoking the provision? I mean,
As of March 10th, there's no question in writing they invoked the appraisal. Prior to that time, as a matter of fact, as a practical matter on the ground, both parties were proceeding with appraisals of the damage. And I would submit that that was consistent with Condition 10 of the policy, which says we get an appraiser, they get an appraiser, and then it's decided with a three-party appraisal panel that includes a neutral umpire. So I think their remedy, after they filed their demand for appraisal on March 10th, if there was no neutral umpire selected, was to go to court and have the court select one. But that's not what they did. Now, the judge's order that denied our motion to compel appraisal also briefly mentioned something about a confiscation rationale, but we would submit that at that time, this trial court and the facts do not support that there was no reason to appraise, even if it was damage attributable to a confiscation, because the confiscation provision that they rely on is in endorsement 8 of the policy, and that excludes damage for delay or loss of use. It includes only physical damage or loss. And in this case, the trial court on October 26, 2004 held that it was a question for the jury as to whether the alleged confiscation had caused any physical loss or damage. Clearly, we know that after that, the aircraft has been returned, so there's definitely no permanent confiscation, and the damages are limited by the exclusions in the policy. Now, we would submit that this aircraft was in no way covered by this particular policy in any event, and I think it's easy to see that by reference to the actual policy. They had, as I mentioned before, they had several aircrafts. The plaintiff owned several aircrafts, all of which were covered by the policy for liability and for personal damage. But endorsement 8 was the provision that provided coverage in certain limited instances of governmental confiscation for confiscation. Now, in this endorsement, there is a specific schedule. There's a Section 7 that includes one aircraft, a 1977 Beech King Air 200, which is not the aircraft at issue. Now, they have argued that you can't look to the specific schedule. Ambiguities have to be resolved against the insurance company. So let's go back to the beginning of the endorsement where it says the endorsement covers physical loss or damage to the aircraft specified in Item 5 of the deck page. But if you go back, their argument is not even creating an ambiguity, because if you go back to the deck page, Item 5 says, please refer to the multiple aircraft endorsement, and that's singular. There is one multiple aircraft endorsement in this policy, and it's endorsement 1. And that's consistent throughout the policy. If you look in some of the other, for example, endorsement 27, there is a reference when they added another airplane after the inception of the policy. They said, add this to endorsement number 1, multiple aircraft endorsement. Okay, so there's no question that the multiple aircraft endorsement is endorsement 1 that has 4 airplanes on it, and any that they might add through other endorsements. But when they added this Lear 35A, which we would submit, there must have been some reason why they didn't want the confiscation coverage, but they did not include this on the multiple aircraft endorsement. It's not there. It's endorsement 19, and it says the only coverages are as follows. And there's bodily injury, property damage, but there's no confiscation coverage. So I think it's very clear from the face of this policy that even if you follow their argument through the deck page and back to the multiple aircraft endorsement, that this 35A is not included within the confiscation coverage. So I think as a matter of law, the summary judgment order on confiscation has to be reversed, and I think we also have to look at the order that denied our motion to compel appraisal and say that that could not possibly have been based on any rational reading of the confiscation clause.
Well, now, Excel was a little late to, unless I'm misunderstanding the facts here, and this is factually complex.
It is.
This coverage problem must have come to XL rather late because there was an offer in, I think, around August of '04 to deposit about $750,000 as the undisputed amount owing. Did the coverage issue just occur later, or how can those things be reconciled?
It's not a total coverage issue. It's not an exclusion that gets XL Specialty out of the policy. There's separate coverages. We did not deny coverage on the total the fact that the plane was damaged when it landed with its gear up. We've always denied coverage, and it's right there in our answer at paragraph 15. We've always denied that it was covered by the portion of the policy that deals with confiscations under government order. And there's no proof of any government order, incidentally, in this case either.
So that schedule only related to confiscation.
Right. And when we paid the money into the registry of the court, that was after we sought to compel appraisal. The policy provides that the first thing you do is to seek appraisal, and then there's no requirement of any payment under condition 10 and 11 until after it's been determined what the damage is pursuant to the appraisal process.
And your limited appraisal that you'd done earlier was consistent with the amount you offered to pay you.
Well, there was an updated amount. There was the initial appraisal, I believe it was in September of '03, and then there was an updated amount later on. And as we learned more information, we would deposit money into the registry of the court and take it to where the undisputed amount was. That was our intent, and that's what we've tried to do all along. So we would submit that the case law is very clear that Florida courts have utilized Chapter 682 to compel appraisals just as they have arbitrations, and that it's well established that this is a binding provision. It's a condition precedent to recovery. And we understand that they have cited several cases that say that if an insurer concedes coverage, then the time for demanding appraisal runs from then. But none of those cases, first of all, they're the ones that demanded appraisal. We had no obligation to. They demanded it on March 10th. Secondly, none of the cases that they're citing deal with this situation where both parties were actively pursuing appraisal, and moreover, where the plaintiff actually demanded an appraisal. And
Did their filing of suit waive their demand for appraisal?
I would submit that it did not. There is very strict case law, including the Franco case out of the First District, that state that it's very...
By filing suit, would they not have abandoned their request for appraisal?
Well, I think when our first action is to move to compel appraisal, that's a ratification, basically, of their request. I don't think that they had the right to abandon it because the appraisal process is a condition precedent to recovery.
You didn't initiate a request for appraisal then until well after the suit was filed.
Well, no, right. The first response to the suit, which was only 34 days after they demanded appraisal. We had been proceeding with an appraisal all along. And the Franco case says once you've moved for an appraisal, that becomes a condition precedent to recovery under the policy. So we think they still have to meet that condition precedent. I'd like to reserve my time for rebuttal.
Mr. Shipp.
My name is Gary Shipman with my partner Bill Whitney. We have the pleasure of representing Aircraft Holdings. I would like to start out by pointing out to the court that both the underlying trial court and the record disagree with the facts as relayed by Mr. Finley a moment ago. This plane crashed in August 2003 in Cancun, Mexico. One and only time did XL ever send anybody down to look at the plane. It was in late August, early September. Westar, who admittedly said that their appraisal was very preliminary and only examined the exterior of the aircraft. As a result of that, during the preceding or the following months, Aircraft Holdings contacted Bombardier, which is the successor in interest to Learjet, the manufacturer of the aircraft, and had them send people down to Mexico. The first time was on September 10, 2003. And I want to point out, this is an important point, prior to even doing that, we, within 2 days of the plane's crash, returned the pre-printed form that the insurance company had sent to Aircraft Holdings asking them to report the loss, in which we reported the loss, and on the box asking what our position was on the amount of the loss, we indicated a total loss. Under the law that we've cited, that served as proof of loss at that point. There was a Condition 10 under this policy, which is nearly identical in language to all of the cases that we cited to the court regarding appraisal, starting way back in 1939 with the Supreme Court case of Bear versus New Jersey, where it had a provision in there where if either party within 60 days of the proof of loss could not agree on the amount of loss, then either party in writing could request that the umpired appraisal process, meaning you have a disinterested third appraisal, make that determination. There's a 60-day time limit. Bear versus New Jersey, Lerner versus Lumbermans, English versus Old American Insurance versus Swain, and American Bankers versus Terry, all cited in our brief, all directly on point, all addressing the identical provision as Provision 10 in this policy, say the time to exercise for an appraisal process is 60 days from the proof of loss, or 60 days from when the insurance company acknowledges liability, which in this case occurred on September 10th, 2003. Now, our Aircraft Holdings, in an attempt to get it resolved, still sent Learjet down there on 3 occasions. And as the trial court correctly found in its order, the last occasion, the occasion in which we had a complete appraisal, including the engines, although they later dispute that, clearly showed that when the amount to repair the plane plus the cost, the value of the salvage, well exceeded the $2.4 million insured value. This would have made, construing it in the light most favorable to XL, the time to have run on February 2nd, 2004. Now, when no response was received at all from XL, and it's important to point out that what the record shows is that between that early September of 2003 until the time we filed suit, they did zero to do anything to adjust this claim. They didn't deny that the Learjet was an appropriate appraisal. They didn't accept it. They didn't go and have Westar go back down. They did zero. They also did zero to cover our insured claim under their policy of freeing our plane from the Mexican government. When nothing happened, on March 10th, 2004, even though the time frame had long since passed, we gave an offer in writing to XL to vote the appraisal process, but we gave them 10 days to do it. And they still did zero. No response. Mr. Rowetter, in his deposition transcript, which is part of the record, testified that he sent it on to Los Angeles, where the company was, and that we should have gotten a response, but we didn't. Finally, out of frustration, Mr. Green, who at the time was representing Aircraft Holdings, calls Mr. Rowetter on April 9, 2004, and says, "What do we have to do to get our claim processed?" And the response was, well, you can take the preliminary estimate from Westar back in September, or you can, quote, do what you have to do against whomever you have to do it against. And by the way, that was pled in the complaint. And it wasn't denied. It was pled. It was testified to by Mr. Green, and it was in Mr. Green's affidavit, all of which are in the record. They dared us to sue them. Now, the law is very clear. When you have a time frame of 60 days to evoke the appraisal process, it's by contract. You have contracted a specific provision with a specific time frame, and it wasn't evoked. In addition, contrary to what is being argued by XL, an appraisal is not exactly the same thing as an arbitration. An appraisal only can address one issue, which is a dispute over the amount of damages. It cannot address the issues like endorsement 8, which the trial court correctly found was at issue in our pleading. And more importantly, XL wanted to talk out of both sides of their mouth during that hearing because they alleged that they wanted to evoke the appraisal process. And at the same time, they argued to the court that they couldn't do an appraisal because they were had frustration of performance because the Mexican government had our airplane. And actually, during that hearing, Mr. Finley, and if you read it, it's cited in the brief, the record citing, the question before the one cited in the brief, Mr. Finley started telling the court how Mr. Kirchin with XL was negotiating with the Mexican government to get our plane released. And Judge Clark, in frustration, said to Mr. Finley, "Is the plane confiscated?" Made him answer the question, and the answer was yes, it was. We then move, and by the way, the pleading in our complaint in which we allege entitlement to endorsement 8 was paragraph 9. And this was their response to paragraph 9. Quote, "With respect to the quoted language of the policy speaks for itself and must be interpreted in its entirety within the context." They never once denied coverage under endorsement 8. They didn't allege it as an affirmative defense, and we had not one but two motions for summary judgment on this particular issue. The first motion for summary judgment that was argued in August, Mr. Finley did not show up and argue, "Oh, we don't have coverage under endorsement 8. Instead, he made this argument that, well, we haven't, even though the plane's confiscated and even though the policy provides that when it's confiscated, you lost your airplane and therefore you're entitled to be paid for what the airplane is insured for, we still have to somehow show what the damage to the airplane is." That's what they argued. They waived any claim that we didn't have coverage under endorsement 8. In addition, under endorsement 8, if you read the policy language, which I hate to act like this, but it's just an absurd allegation they're making. The policy was the original policy was issued before this aircraft was added to the policy. And the policy on the declaration page under item 5 says description of aircraft and physical damage coverage. Please refer to the multiple aircrafts endorsement, physical damage, war hijacking, extortion, etc. You go to endorsement 8. Endorsement 8 on the very first line says, subject to the terms, conditions, and limitations set out below, this endorsement covers physical loss of or damage to the aircraft specified in item 5 of the declaration page. Nowhere in endorsement 8 does it tell you what section 7, part 1, which is what they're referring to as the schedule of aircraft, is for. Nor does it tell you anywhere actually in the whole policy what it's for. You then go to endorsement 19, where this aircraft was added. It adds it under item 5, description of aircraft and physical damage coverage, and under physical damage coverage, all risk basis. At best, we think it's clear that if you're under 5, you got the coverage, but at best, it's ambiguous. And Judge Clark correctly found that that would provide coverage for us.
Ambiguous whether physical damage, all risk basis includes the risk of confiscation.
Yes, sir.
And so the judge would have to presumably answer that question as a matter of law in any event.
Right. And under the case law, she has to find, since they drafted the insurance policy, in our favor. But we don't believe you even have to get there because we think they waived any argument on coverage. Since they didn't deny it, I don't believe when they say with respect to the quoted language of the policy speaks for itself, that that is a denial of coverage. That still leaves us trying to figure out what the policy says. They didn't raise it as an affirmative defense, and they didn't raise it in the first argument opposing summary judgment on this issue. We also, before you even get there, we take the position that they waived their right to appeal on the issue of the $2.4 million, because before judgment was even entered in this case, they paid the $2.4 million. They paid it after the summary order granting summary judgment was issued, but they paid it at least, I believe it was a month before the actual judgment was entered. And what's important is after the court granted summary judgment, they still fought us over what the actual judgment was. So in summary, what we would say is appraisal is inappropriate because, number one, it wasn't timely asked for. Number two, when we offered outside the contract to do it and gave them 10 days, they still didn't accept it. Number three, when they told us to, quote, do what you got to do, get to whoever you got to do it to, that is behavior that is inconsistent with their desire to resolve the claim through an appraisal process or any other process. That is language saying, go sue us, which is what they forced us to do. The plane was confiscated. Their agent, Mr. Fenley, on direct questioning by the court, told them it was confiscated. The plane, and it doesn't have to be confiscated, all it has to do is be detained under the policy. There was a question regarding, well, what does detained mean, and how do you evoke this policy? Well, we asked every single person connected with Excel in deposition, what does this mean? Mr. Rowetter, he had no idea. He hadn't even looked at it. He wasn't even sure it was in the policy. We asked Mr. Kirchen. He didn't know. He'd have to go research it. It's all on the record. Mr. Kern, what does this mean? Head of Kern & Woolley, the Beverly Hills law firm that represented this insurance company. I don't know. I'd have to research it. Mr. Bland, the original adjuster on the case. I don't know. I was never asked to research that issue. And Mr. Gould, the only person with Excel who apparently had any connection with this claim. And his answer was, I don't know. You'd have to ask Kern & Woolley. So they didn't know. So we went out and hired Mr. Bosselman and Mr. Grisham, who both presented affidavits that the trial judge considered. And by the way, the summary judgment was 1 week before trial was to begin. And they both said this is a standard provision in the industry. And what it means is that if a plane is seized by a foreign government or authority, that within 30 to 60 days, the insurance company is to go obtain the release, or it's declared a total loss, and you pay off the plane, and then you, insurance company, own the plane. That was unrebutted. They had no testimony opposing that interpretation, and the trial judge correctly accepted that testimony as part of her order in granting summary judgment on the issue of endorsement 8. And this finally, I would also add that the trial judge found when they voluntarily paid money 7 months after we sued them, it was November. That was a confession of judgment that they owed us at least some money. And that money was known to them at least as far back as 9 months before we sued them. And they never tendered anything. I see my time's up. Thank you.
The first point I'd like to address is his argument that we did not deny, or that we did not raise the issue of endorsement 8. That issue, he's left off the critical paragraph. Paragraph 15 of the amended complaint said that the plaintiff alleges that in addition or in the alternative, subject Learjet is a constructive total loss due to confiscation, seizure, restraint, or detention by order of the government authorities of Cancun, Mexico. Defendant XL has breached the subject policy and that it failed and refused to pay the policy proceeds due under endorsement 8 of the policy. Flat denied. totally denied. That issue was litigated throughout the proceedings with the consent of the parties. There is no possibility that we waive that issue. Right there in the first pleading. Secondly, with respect to his argument about the coverage and the reading of endorsement 8, he said if it's on item 5 of the declaration page, it should be covered under endorsement 8. Well, it's not. It's not listed. It says, please refer to multiple aircraft endorsement, which has 4 airplanes, and this is not one of those airplanes. With respect to the argument that he makes about the case law that's...
What about the use of the phrase all risk basis in endorsement 19? What's your response to that argument?
Well, I'm not sure I really understand it. I would say that endorsement 19 is for the Learjet. When it was added, it says the insurance afforded is only with respect to the following coverages, and then it lists those coverages. That does not include any all risks, and it does not include any confiscation coverage. We also submitted an affidavit from Ernest Despain, who said that they did not purchase, they purchased coverage on only one aircraft, the 1977 Beech King, and they attached a letter that they sent to the
Go
plaintiff.
back to what you just said about endorsement 19 not covering.
I understand the question. I apologize.
Well, you've got liability coverage, and then you've got physical damage coverage, which I suppose is the hull insurance. Why is that aircraft not added completely to the policy in all respects?
Well, both are commercially sophisticated parties in this case. They added a great deal of insurance coverage on June 11th, which you can see by going through all of these endorsements. And unlike, if you look at endorsement 27, there's another aircraft that's added. On that aircraft, it's a N233P. They specifically added it and referenced endorsement number 1, multiple aircraft endorsement. So they know how to do this when they want to purchase that coverage. But why they didn't purchase the extra coverage on this one, I don't know. I would note that it has a higher insured value.
Well, all the amendment there on endorsement number 1 is to add the airplane, isn't it?
That's another airplane.
That's
though.
clearly done with endorsement 19, I would think.
No, it doesn't refer. It doesn't add it to multiple aircraft endorsement number 1. It does not do that, and they know how to do that because they did it differently when they added another airplane. So I think there's no ambiguity in that respect. With respect to his argument that
I think your time's about up, and I'm giving you a little over a minute.
Well, I appreciate you. You said you're giving me an extra
No,
minute?
I have given you a minute and a half now, actually, over
Okay.
your time.
All right. Well, I thank you.
Thank you very much, Mr. Kennedy.